Well, we're going to talk about disputes and litigation around trade secrets. These are things you want to avoid, but you want to be prepared for them so that you can get through it successfully. So what causes disputes in the world of trade secrets? The studies that have been done on this show that most loss occurs through employees, and my own experience bears that out. But we also see a lot of litigation, and increasingly these days, that comes up between businesses. And that's because there's a lot of information sharing that happens in the modern economy. And so misunderstandings or disagreements about those relationships sometimes can lead to a dispute. Very occasionally, there is something like outright espionage or theft. But compared to the headlines about it, there's actually a lot less of that than you would think. Most trade secret disputes happen because of mistakes and misunderstandings between the parties. And that should give you a clue about how successful you can be about avoiding these disputes. So let's talk about what the risks are of trade secret litigation. You should be thinking about that. If you're in a dispute and you're thinking, well, I'll go to court and get my trade secrets backed up by a judge. What's involved? What are the risks? Well, obviously, you're going to spend a lot of money. It's not quite the sport of kings, but it's very, very expensive to engage in trade secret litigation. So you need to think that through. But it's not just about the cost. You're in a business with other people that you're working with, your employees, your managers, and in a trade secret dispute, they typically will be distracted by this drama that's going on, and people will be wanting to watch it, learn about it. Your productivity may suffer, particularly as people have to take time out from their normal work to sit for depositions or help the lawyers understand what's going on in the case. And then you may end up, depending on the kind of business that you're in, actually annoying your customers because they get involved sometimes in the process of discovery, which is the fact-finding of these kinds of cases. The main thing to remember about litigation is that in trade secrets, when you feel like you've been wronged, your perspective may be not quite what it should be. There's a lot of emotion that feeds into these kinds of cases. There are feelings of treachery and betrayal and abandonment and things like that. And so it's easy to get into a mode of reaction rather than careful, sober planning. So just be aware of that. So when a dispute comes up, what should you be doing? First rule is what I just mentioned a moment ago, which is to be aware of your own emotional reactions. And this applies on both sides. The person or company that's being accused of trade secret misappropriation may feel itself being victimized and unfairly attacked. So there's a vast difference in perspective and context for the two parties in the dispute to begin with. As a potential plaintiff, if you're the one with the trade secret and you think that someone that you've entrusted with it has not done what they should, either another business or a departing employee, the first thing to do is investigate carefully. Make sure you know everything you can know about the facts. Consider carefully what your strategy should be. What is it you're trying to achieve? You mostly want to stop the misuse of your information. Do you need to go to litigation for that? Or will it work that you just send a strongly worded letter, demand a meeting, and try to see if you can work it out? Ultimately, if you are going into litigation, you will be wanting something to come from that that stops whatever it is the defendant is doing, and also to pay you compensation for the loss that you've suffered, and perhaps also for the fees that you're going to have to incur. For the defendant, it's a very different strategy. And the strategy is try to get it off the litigation track. Try to get the plaintiff talking so that you can explore whether there are ways outside of litigation to resolve the differences between you, because it's very easy to allow the litigation to sort of take over and develop a life of its own. And that is almost always a bad decision from the defendant's perspective. So what are the key stages of litigation? And, well, there is the very beginning, which, as I mentioned earlier, usually involves a fair amount of mutual distrust and anger and unpreparedness, because you don't really have context for understanding fully what has happened. The plaintiff doesn't really know what the defendant has done with the information. They have suspicions. They may be very reasonable, well-grounded suspicions, but you don't know. You don't know the extent of it. And the defendant, the person who's being accused of taking information, doesn't really know where this is going to lead. It looks really scary and so forth. Well, if it starts with a request to meet and talk, then everybody is well positioned to try to find an outcome. And early settlement negotiations are always a good idea for both sides. But if that doesn't work, one of the very first things that'll happen is the plaintiff will be filing their lawsuit and asking the judge to issue temporary orders to stop the defendant from doing whatever it is that they're doing with the information. Sometimes we refer to these as a temporary restraining order that's in place until a few weeks later, the two parties can come back to court and the plaintiff will be asking for a preliminary injunction. That's an order that will stop the defendant from doing certain things until the trial happens. That's the first major stage of litigation, and cases often settle at that stage because either the plaintiff has been able to get a strong injunction or sometimes none at all, and so the parties tend to reassess. What happens next is called discovery, and that's something that is almost unique to the United States, where each side in a litigation gets to ask the other for information that they know, documents, taking sworn testimony and depositions. This takes quite a long time and engages the lawyers quite a bit and is very expensive, but it is the way in which you get informed about what's going on with the other side, and perhaps a beginning of understanding about what the dimensions of a possible settlement of the case might be. Ultimately, before the trial happens, there will usually be a settlement conference that the judge requires both sides to do. And there will be a professional mediator whose job it is to try to help both sides kind of calm down a little bit, understand each other's perspective, and most importantly, look for ways that you might be able to find mutual benefit in some negotiated outcome. It's very hard for people who are, if you will, at war with each other to understand what the possibilities are for some continued relationship. In this sense, I found it very helpful to think about trade secret litigation just like a divorce. In fact, early in my career, I handled divorces, and at one point, it became pretty clear to me that that experience was very helpful in understanding the kind of emotional content that sometimes comes up in trade secret litigation, and that you have to address if you're going to get an outcome that is acceptable to both sides. If none of that works, you will go to trial, and usually there will be a jury. that may not understand your business or the technology involved or any of that, but they get to decide who's right and who's wrong. And so that represents a certain level of risk. So let me just tell you, I'll give you one example of the kind of unpredictability that characterizes trade secret litigation. There was a company several years ago that hired another company to create a software tool for it, and it didn't get what it wanted. It thought the product wasn't so good, and so they refused to pay. And in fact, they sued the software company to recover for some of the money that they had already paid. In the course of discovery in that contract action, the defendant discovered that the plaintiff that had hired them had actually taken the information that they had provided to them and used it in violation of their agreement to create their own software package internally. And so all of a sudden, the defendant then got permission from the court to file their own claim for misappropriation of trade secrets. $70 million later, the plaintiff was looking at having to pay that huge judgment to the defendant. So the lesson here is there's a lot of unpredictability, and you may not know everything that you need to know until you get through discovery. So do what you can at an early stage to investigate and to talk with the other side so that you can be informed about what's a good outcome.